Hey everyone and welcome to Research channel. As you have seen that some of the questions from RTI Act in 2021 attempt they were asked, and so for the next attempt it's apprehended that questions relating to case laws relating to this act might come. So do watch this video to know the important judgments covered under RTI Act 2005, and please note that soon I'll make video on important sections of RTI Act, so stay tuned with this channel. So our first case is Chief Information Officer versus High Court of Gujarat. So it's a recent case in which it was held that third parties, if they want to have access to information, they are required to file an application or an affidavit stating the reasons according to the prescribed procedure which was mentioned in the Gujarat High Court rules, rather than moving to the RTI Act. So this case has basically faced some kind of backlash also because in any way it has undermined the importance of RTI Act. So our second case is CBSE versus Additive and it is a case of year 2011, in which the court held that the corrected answer sheets of a candidate appearing in a public examination and conducted by the statutory bodies like CBSE. So the corrected answer sheets, they are the document or a manuscript record and an opinion which fell under the ambit of information which is being defined under section 2F of RTI Act. Also, it was held that the CBSE, it wasn't in a fiduciary relation with the candidate, so there is no scope that it can be exempted under Section 8, Clause 1 and Subclause E of RTI Act. So therefore, through this case, the apex court directed the examining bodies in general and the CBSE in the present matter to permit examinees to have an inspection of their answer books. Our third case is Namita Sharma versus Union of India, wherein the constitutional validity of Section 12 clauses 5 and 6 and Section 15 clauses 5 and 6 of RTI Act were challenged. And these sections basically address the appointment of individuals to Information Commissions. Hence, the court held that the Information Commissions, they are the judicial tribunals and they are performing the functions of wide magnitude, including functions of judicial and the quasi-judicial nature. And while passing the order, they should follow the principles of natural justice. Our next case is Archijan versus Union of India, wherein the Supreme Court held that the document known as Annual Confidential Reports, in short we may call it as ACR, of a public officer is considered to be a personal information, and it is therefore exempted from the mandatory disclosure to a third person under the RTI Act. The court also reiterated that it was the prerogative of the competent authority to decide that if such information could be disclosed in a greater public interest, but that the petitioner cannot claim these details as a matter of right. So our last case is State of UP versus vraj, narendra. So you must have read this landmark judgment under your constitutional law. Now why to consider this case under the RTI? So in this case, the Supreme Court held that the right to information will be treated as a fundamental right under Article 19. The Supreme Court also held that in an Indian democracy, people are the masters and they have the right to know about the working of the government. Hence, we may consider this case as a first case that dealt with the right to information. So, these were some important judgments. If you want to know any other case law under RTI Act, then do suggest in the comment section box. Thank you for watching this video. Please like and share this video with your friends and do subscribe to Research Academy to get the further updates.